established agenda here for the city council meeting for this call meeting. Do I hear a motion? Got a motion, Mr. Simmons. Thank you, sir. Here a second. Thank you, Mr. Rockwell. Any discussion? All in favor, signify by saying aye. Aye. Any opposed? Okay, first item on the agenda, new business, Mr. McCray.
The first item of business is a memorandum of understanding which we have completed with the Attorney General regarding the violations of the Open Records Act. All of you have been provided with the final document we obtained from the Attorney General's office. And I want to go through, I'm sure you've read it, I'm not going to read the whole thing to everyone here, but I'm glad to answer questions. The first phase of the MOU of understanding concerns the requirements of the Act that's set forth in the code. After that is done, and that's the first 2 pages, the third page is the admissions of violations. I'm going to go through that to some degree with you again for members of the public and the press who are here and for y'all. This written document will be, if approved, will be there for everyone to see. The first admission is that there were potentially text messages exchanged concerning city business in response to the open records request. These were that the city got erroneous legal advice that the text messages are not subject to the Open Records Act. I think I've told you this before, but let me say it again. Any text messages or anything else that is written concerning matters that are not part of any form of privilege or confidentiality are subject to the Open Records Act and have to be disclosed. Number 2 says that the city admits the violation of the Open Records Act on March 2, 2016 because the city clerk was interviewed and she is not the, quote, executive head of an agency. I'll say for the record that I disagree with the Attorney General's interpretation of the Act. The clerk is an executive head of a department of this city. I think you had every right to have that discussion in the executive session. I cannot tell you how many times we've done the same thing in other cities I've represented, but in order to resolve the matter, we are going to admit that that is a violation of the Act, and the Attorney General's interpretation is different from my interpretation. Number 3, the City of Temple admits a violation of the Act in that executive sessions were held without an executed and filed notarized affidavit. That was done. This was on December 9, 2015, in March and April and May of 16. Since we have been your attorneys, we do have an affidavit. We've not had an executive session since I've been here, but that affidavit given to Kristen, we have it, and if we had a need for an executive session ever, the document is now something that she has and is in good form and complies with Georgia law. Number 4. The city admits a violation of the Act in that they did not approve official minutes of council meetings that occurred until later on. You were between clerks, as I understand it. That is a problem. But remember, normally, unless there's some real issue or somebody's sick or whatever, you have meetings at the next meeting, or certainly at the next regular meeting, you're going to want to approve regular minutes, special minutes, and then if you do have an executive session, they're not open to the public to review, but you need to review those because it's my position and always has been that executive session minutes should be taken so that everyone has an understanding of what was done in the executive session and that it does comply with the Act. And like an example, if you're involved in some matter of litigation and you tell me to settle the litigation and for some reason I don't do that, then that's a matter you need to bring up with me, reversed. If you tell me not to settle it, you tell me to settle it for an amount of money and I don't, then that's a problem. Or any other things that would come within privileges in executive session that you need minutes about. There are other statements that says you will comply with the Act and that you will no longer do these things, and that and I would say this to you, and I said it to you earlier in my memorandum, Do you agree that the training session will be conducted for staff concerning the Open Meetings Act and the Open Records Act? And the training will be provided by the Attorney General's office. That's wonderful for them to do that, not charging anything for it. If any of you can, when the training is there, come. And if you can't, you might want to get Kristen or Bill or anybody on the staff who helps to actually record that so you can have it, so you can hear it at some other time. You agree to pay a fine of $1,000 for the violations, understanding that if you violated the act again within a year, the fine would be $2,500. I hope that that does not occur, and you need to be very careful that it does not occur. And it requires the signature of the mayor and members of the council and the new Attorney General of Georgia, Christopher M. Carr. Questions?
Requires all the council members and the mayor to sign it tonight?
Yes, sir. Yes, sir. After approval. But I wanted to answer questions before I ask you to approve it. Hearing no questions, Mayor, the matter would be before you for a motion and second to approve the memorandum of understanding and for the mayor and members of the council to sign the document.
I hear a motion, we approve the memorandum of understanding as stated.
Motion.
And a motion by Mr. Simmons. Do I hear a second? Second by Mr. Walden. Any discussion? Yes, ma'am.
I just want to state that in this, and after reviewing each and every one of these in here, there is only one meeting in which I would have participated in what would have been considered to be a violation, and then I was the one with the interviewing of the clerk. However, at that point, prior to that meeting, I had not attended an executive session for close to 13 to 14 months. I did contact Mr. Osborne. He had checked, contacted me back, said yes, he believed it was okay. I had actually called the Attorney General myself, and the information I was given that day led me to believe, due to the way our charter was written, being that the council in full authority hired or dismissed the clerk. I felt good about that. However, I did ask for the affidavit, which wasn't presented. By signing this and by the motion in the second to sign this, none of the rest of these were something that I participated in. So when I'm signing this, I'm signing with the understanding that I agree, that I have knowledge that these things occurred or that they did happen. I'm in agreement that these issues did happen, but I'm not signing this in any way that states I participated in these violations. So that's all I have to say in discussion.
Any more comments? Okay, all in favor, signify by saying aye.
Aye.
Any opposed? It's carried.
And I have the document here, and I'll start with Ms. Ransom if y'all would sign it and send it around. The second matter,
Can I have that where I go ahead and sign this? I'm gonna let you and Mr. Bracknell handle the second matter.
that's fine. And let me let y'all, go ahead. I'll let y'all sign the first one then, Mayor. And I won't go to the second one now until everybody signs the first one.
Thanks.
It stinks really bad here. Over that stuff.
It smells so bad.
Is that coming from the duck?
It's coming from top there.
I can tell you where
It wasn't like this when we turned the air conditioner on.
you smell it good, right? It's apropos to this meeting. I think it died at this table. Giggling. Are you going?
I want to then give it to Mr. Osborne, and if the minutes would reflect it's been approved, and we'll send their version to them tomorrow, the original that was marked, Madam Clerk, and keep a copy here. And for any of the members, for the public who want it now that it's been officially done, we could make a copy for them. Some of these folks may want to take it with them or whatever, especially members of the press. I'm sorry. The question, this is a good question for the public. The question is, does it stay on file to the Attorney General's office? The answer is that yes.
That should.
And it would stay on file with the Attorney General's office through the end of the record retention policy of the state, which, depending on the nature of the record, this one would at least be 7 years. And now, as you take over, Mayor Pro Tem, the second matter I have is a matter of settlement of litigation, and as such, because you've got to receive that as a part of officially tonight, we would need to discuss that in regular session and not special session. So,
Okay, report by the city attorney considering a court-approved resolution of the litigation between Mayor Lester Harmon, City Administrator Bill Osborne, City Council members Richard Bracknell, Todd Rothwell, Howard Walden. Mr. McCray.
thank you, sir. When I first, I guess the first meeting I ever attended of the City of Temple, I found out that that day, or certainly right around that same period of time, this lawsuit had been filed. And the lawsuit itself had allegations by the mayor with regard to improper actions by the council in the approval of some expenditures for Mr. Osborne. The second part of that is that he was entitled to reimbursement for fees when he was sued in his individual and capacity as the mayor in a prior piece of litigation that he asked to be reimbursed for. There was a counterclaim filed by the members of the council that had a number of things in it with regard to issues associated with the governance of the city. I asked everyone before we ever even started to get into the substance of this, for the sake of Temple and its citizens, to end the litigation. And I'm thankful that that's occurred. There were no hearings. There were no court-ordered discovery. There were no pleadings. There were no other things that happened to alienate further the situation involving this litigation. It is never a good situation when you have litigation within the mayor and council. My first time in 42 years that I've seen it. I hope it is the last time I see it. And I'm sorry that it occurred. I want to tell you this, that when the lawyers for the parties got together and both of them did a really professional job of understanding the larger issue that this needed to be resolved for the benefit of the citizens of Temple. Both of them agreed to stand down, so to speak, and to allow the matter to end, provided there were some statements placed in the settlement document concerning how things operate in the mayor and council system of the city of Temple. And that wording, the reason it's taken a while, that wording has gone back and forth between the lawyers and y'all and the mayor, looking at all these matters, and finally it has been approved. Secondly, this had to be approved by a superior court judge. He had to review the matter, review what had gone on in this case, and agree to the approval of this, and he did. So the matter is before you as a matter of information. It does not require your vote. It has been approved and filed with the court. I'm sorry, ma'am, is there something funny about all this?
Yes, sir, it is.
Well, I want to say this to you. I have listened to you in the past belittle what is going on in this process. That is not what governance of any municipality is about. I ask that the problem be resolved without litigation and without any further matters being taken care of by anybody.
But
And
the
that was
people of Temple are having to pay for it.
that was what was done. Had this gone on, the bill to the people of Temple could have been 4 times or 5 times what it was.
Why isn't the bill
Let-
given to the people who
Let
break
me
the law?
finish. Part 2. The last time I became involved in trying to help somebody in a matter of litigation in federal court, they did not resolve it like they did here. What happened was they were hit with attorney's fees of $165,000 the taxpayers had to pay. I hope and pray that would never happen. But to laugh at something when you end litigation is improper.
I hope and pray that our elected officials would not break the law of our charter too, but it didn't happen.
I'm not going to get into a discussion of that. I just feel very strongly that the matter has been resolved, and I would ask that the proper decorum occur while we're having a discussion about it. Now, back to the settlement agreement. The terms will be there for all members of the public to have. And the terms are very important because there is one point of which we do agree, and that is that the governance documents and the charter of the City of Temple need to be adhered to. Now, what the document provides for, approved by the court, is this. The City of Temple charter is the governing document of the city. Mr. Osborne will be reimbursed for the consulting fee of $2,000 he paid to Ms. Alston for her consulting agreement. Number 3, no written contracts of any nature for which the city is liable for payment shall be entered into without the prior review and approval of the City Council. Let me say that again. All contract documents must be reviewed and approved by the council. Okay? Upon your approval, those contracts shall be executed by the mayor. Number 4, in the prior litigation, the mayor was sued personally, Rick Ford versus the City of Temple. He asked for the reimbursement of fees which did not occur. In my opinion, he had the right to ask for that, or it would have been a contested matter about that or other fees. The settlement of the agreement was that the mayor will be reimbursed through his council for $6,000. These fees were not a part of the suit, but Mayor Harmon requested the same as a part of a global resolution of these matters. Mr. Harmon has retained his lawyer and felt there was a conflict between the insurance company lawyer handling the matter and himself. He got his own personal lawyer to do that. That's happened before several times. Sometimes you pay for the lawyer, sometimes you don't. The agreement provides to pay $6,000 toward that legal bill. Next, the City of Temple shall pay Mayor Harmon's attorney in this litigation $7,500 and the respondent's litigation, Ms. Daly, the sum of $5,000. These were suits filed in your name and in your behalf as elected officials, and therefore these invoices are properly to be paid, and the court took the position they were proper and should be paid. Number 6, the parties agree and understand that the charter adopted in 2010 changed the form of government in the City of Temple from having the mayor as the chief executive officer running the day-to-day operations to having the city administrator run the day-to-day operations. Legislative power is vested in the City Council. Let me repeat that. Legislative power is vested in the City Council except as otherwise provided by law or the city charter. Number 7, the parties agree and understand that if there is a city administrator, the city administrator for the City of Temple is in charge of the day-to-day operations of the city. including but not limited to the authority to direct and supervise the administration of all departments, officers, and agencies of the city. Number 8, the parties agree and understand that the responsibility for holding and running department head meetings belongs to the city administrator. No elected official will run any department head meeting unless the city does not have a person in the position of city administrator, or unless the city administrator requests an elected official to do so. Number 9, the parties agree and understand that the charter explicitly provides that no elected official may interfere with the city administrator and employees of the city under the direction of the city administrator. Number 10, the parties agree and understand that the charter provides that the mayor provides the mayor with the power to appoint and remove all officers, department heads, and employees with approval of the city council. The city administrator is empowered under the charter to recommend appointments to the city council and mayor, and to recommend suspensions and/or the removal of city employees to the city council and mayor. Number 11, the parties agree and understand that conflicts between the charter and city personnel policies must be dealt with through the legislative process of amending either or both the charter and the personnel policies to bring the two in harmony. With regard to number 11, as you know, you're already involved in a review of your personnel policies and to bring those into harmony with your city charter. And there, as you know, I've already told you there's some areas you need to change in that regard. I think these provisions make much clearer the duties and responsibilities of the mayor and the duties and responsibilities of the city council. I want to thank you again for agreeing to not go forward with the litigation and allowing us to resolve it and answer questions. Mr. Simmons.
I'm the only one that was here when we went through the process of changing from a male-dominated type of government to a council-dominated type of government. We felt that it would be more fair to employees and the citizens of the company if we had more than one person making some of the more important decisions. That's why we did that. If I remember correctly, I think we started this process when Mr. Harmon was mayor the first time. And at the time, he was in most agreement with everything that was going on. We call ourselves taking away from the mayor the power to hire, fire, promote, and demote. From reading what you said right here, on some of the things you said, the power of the mayor, about appointment and things like this. Does that give the mayor the power to promote, hire, fire, promote, and demote?
It does not himself. He has the charter, present charter provides, let me read it again, the mayor with the power to appoint and remove all officers, department heads, and employees with the approval of the city council.
There are some other things that the council, some of the members of the council have been just talking about and things like this about Mayor Harmon. I'm not going to call any names or anything like that. One thing he mentioned that he was in the process of appeal, had employees appealing to the head of the department, then to the administrator, and then to him as mayor. I don't see anywhere in the charter where the mayor is in that process whatsoever. But the charter said that the city council have the duty and power to carry on the government of the city. Now, my thinking like that is that the mayor shouldn't be involved in that process. But since the council have that power, that if they wanted to appeal it higher than the city administrator, they will have to get approval of the city council.
That's right, to some degree, but let me say this. What we talked about at the last meeting, what you gotta decide about is, how do you want this to go in the future? And what I've seen in my years of experience is that when X has the right to appeal to the mayor and council, it becomes political. And what you got to decide, and I'm not telling you how you decide that, but normally what you see and what in my forms I've given you to think about, Mr. Simmons, is anybody who's employed within a department appeals first to their department head, secondly to the city administrator, but that's it. All department heads appeal to y'all, the mayor and council. And I'm not elected, and I'm not the one who ultimately makes that decision, Mr. Simmons, but I can't tell you how many times I've seen somebody who did something very wrong and should have been fired. The chief of police, and one I'm thinking about, said fire him. The city administrator said that, fire them. And we're in a small room, but this was a lot bigger room. They must have had 250 people there getting up and saying this is a great person. Well, that great person made a terrible mistake. And because of political pressure, the mayor and council voted to reinstate him. And that was a disaster for the city, and that person created numerous problems until they left. But again, Mr. Simmons, that's not my decision, but you've got to make that decision. There is a kind of the charter's not real clear on that, and we're going to make it clear and make your personnel policies clear. And I'm glad you brought it up, because everybody needs to be thinking about that as to what you're going to do about personnel appeals and whether everybody's going to come up to y'all or not.
Were you finished?
We're gonna have to make several amendments to our charter, I think, in the future. Another thing that some of the councilmen have talked about, the mayor has been in the process of them interviewing applicants for employment. Nowhere in this here charter does it say anything that the mayor should be involved in the application process.
That's his responsibility.
Okay.
Well, let me, before you finish, Ms. Ransom is indicating this in the handbook. And again, the handbook and the charter are in conflict. That's what it says in one of these provisions. And that goes back to, and that's kind of a specific thank you for that specific. And we got to change that so that the handbook will be done away with. We'll have a personnel policy in lieu of that, and those things will be harmonized as to who does what.
Can I say one thing about that, just really quick?
Mr. Simmons, have you finished?
I'll just answer what he just said, then you go right back. But in the charter, in your copy of the charter, right up under where you're talking about the administrator's powers, there's a clause right up under that. It says, except as otherwise provided by personnel policies to be adopted pursuant to this charter. So what you're talking about was then adopted pursuant to the charter in the handbook, and that's how come that's all been addressed that way.
The handbook is over the charter is over the handbook.
Right, but the charter said pursuant to the handbook, and it mentions the handbook in the charter in that section. That's where the confusion comes in.
There's gonna have to be changes made between the charter and the handbook.
That's right, because we don't want any confusion in the future. Okay?
So, without let me finish. Another thing, and there's nothing in the charter that says the mayor has, well, that's like I mentioned before, we took that power away from the mayor, promoting and demoting. So that should be adhered to, right?
Yes, sir.
Okay. Well, Well, a lot of misunderstanding and things like that between the council and the mayor and whatnot. And I think one of the best things that we can have is the city government is to have a workshop or work session with you person, so we can line out some of these discrepancies, differences and things like that.
Well, and let me say, and I think I told several of y'all this, I know I told Mr. Osborne this the first day I came, you definitely need one of those. And the Georgia Municipal Association will do it for you for free. I'm glad to come for free. And they have a lot of great people that'll help you with personnel things and governance things. And, you know, one of the things I wanted to do, kind of, this is an old school thing, bury the hatchet and get this behind us, Mr. Simmons, because it helps nobody in the city of Temple, okay? None of this helps anybody. It continuing was a poison that would have continued for the city of Temple. So thank the Lord it's behind us, but you're right, as quick as we can, everybody's got to be on the same page. It's hard enough to govern any town, anywhere, if everybody's on the same page. We ain't got to all like each other, but we got to get on as much of the same page as we can.
Well, you know, like I said, I had a lot to do with the changing of this, but you have some people who try to tell you what you mean when you make a certain statement within the charter and whatnot. And I also know that I spoke out a lot, as well as the other members of the council and government at the time and whatnot. And I know the true feelings we had behind this. For example, there was a statement read by you a while ago where said that no elected official shall interfere with the city administrator or anything in some of his working and whatnot. And there was a statement right down below that in the charter where we as council members got to talking between ourselves, and we said that the situation may come up where we may not want to go through the city administrator. And then we made a statement, and this is written in the charter, that we, you know, like if we're talking and some employees come to us about an issue, that we may use our own discretion to go around the city administrator. And I'll show you that before we leave here in the charter.
Any other comments?
I'm good.
Ms. Ramsey?
I've come across some questions, and I just want to make a statement first. I've never saw a lawsuit as far as my understanding from any comments that I heard from the second that this was reported in the paper was that this had nothing to do with the city, that this was individuals in individual capacity. I didn't get updates here. There's not been anything. The only thing I recall was, I guess, December when I asked a question and you asked Mr. Bratton on that. That was it. It had to do with the table. I didn't understand why an employment matter or pay matter was tabled. So I've been completely out of this on any way. So when I got this yesterday, there are two things in here that I am extremely confused about. And if you can play, I get it, you've done it, it's signed. But there's two parts that I don't even know how to make it meet in my mind, so maybe you can help me. The first being, I get totally that the legislative power is vested with the council, and I am in 100% agreement with that. But when the council legislates a procurement policy, and we updated it 2 years ago, and we take the employees and we put the employees through this training class, and then we had a council meeting where the city attorney at the time, who I now found out is the same attorney that's represented 3 members of this council, gave the training class. And we sat here in a council meeting, and she made employees stand up one-on-one and answer the questions. And one of the things that was just over and over again is if you go into an expense without a purchase order, without the council's approval, you are liable for that expense out of your own pocket. Turn to our recreation department head and said, what happens, Mr. This, if you do this? He said, I have to pay for that out of my own pocket. They did this in a council meeting, made them stand up. So when this was presented in a council meeting, with me having no indication this was going to litigation, I'm sitting here during the council meeting when this occurred saying you can't vote against what you've legislated. And what you legislated was if somebody went into an agreement and cost the city money without the contract being correct or without a purchase order or without approval, you're responsible for that. So if the council's legislating and they legislate these rules, but then they allow individuals to break those rules and reimburse them, that was my number one concern, is that we were violating something we as a council had just redone and done training on. So that was number one. It ends up going to litigation, which I'm supposedly not named in. My understanding is it had to do with violating the mayor's powers to do this because they didn't do it correctly and they violated their procurement policy. I don't know. I told Mr. Osborne when he called me, why is this on the city council agenda? I did not understand. If the full council had not been kept up to date in this or notified of this, I was totally unaware of why we as a council, were doing this tonight until I got this and realized because the taxpayers are paying the bill for the lawyer fees. So this gets into the next part that I can't understand and help me out. I get that, you have a quorum of the council involved in this, but you have conflict of interest laws. And each time these council members sign this, they signed an agreement where they're financially benefiting from this agreement by their bills being paid while none of the rest of us are. And it wasn't done here to begin with for me to feel like, how come I'm taking responsibility for this now? Because I tried to handle it in that meeting when I said, y'all don't do this. Mr. Simmons, whether he didn't agree or disagree, I remember very clearly that night, you just simply said, I want legal advice first. We didn't have a lawyer here that night. It got done with no lawyer. So I never thought it was going to go here. I sure never thought it would end up here. But now I'm getting into have we circumvented the conflict of interest laws and trying to end something that can cause more problems. Because the only ones who sign this, from the mayor to a quorum of the council, are financially benefiting from this agreement. While I agree with what you got in the lines on how we're going to hear stuff and put things in harmony, we had that with or without this agreement. Our charter is clear, and once we do these handbooks and whatever amendments need to be made to a charter, but then, my question is going to be, and when I went hunting for it, I'm a researcher, so when I saw this last night, I did not know anything about this until last night. First thing I did was start researching, and it was your 108-page document that came up on conflict of interest, and I read it. I read as much of it as I could. So if you can explain to me how we're able to do this, and maybe the taxpayers will understand how come we didn't get to vote, because one of the first things I thought of was when Mr. Ford, as mayor, incurred attorney fees that were not covered by the insurance. And I called back yesterday and asked Mr. Osborne, did our insurance not cover this? Is this the city? He said, no, the insurance did not. It wasn't there, it's not here. Okay, well, when Mr. Ford had that situation, he recused himself, and members of the council, I guess, voted to pay. We got to vote. And even when the situation arose where I had turned in the letter confidentially to city attorney at the time, Cynthia Daly, when they got ready to say, hey, we want an outside firm to come in and do this, I had the opportunity to not vote for that. So when it comes to spending money and taxpayer money, my whole part of being here is I thought I got a say, or at least a vote, before we spent the money. So if you can kind of explain to me how this is not circumventing, the rules that deal with the personal interest or financial interest, and how come we didn't get an opportunity to somehow vote. I don't understand.
I guess I have two responses. Number one is that had this matter gone on to litigation, I don't know where we would be with all the issues you're bringing up.
Right.
So whatever would have happened or not happened, and I'll go back to my temper tantrum a while ago, which I apologize for. There is no question that we would have gotten into serious issues about the problems associated with the litigation had it gone on, and spent more and more fees for the reason that The lawsuit is couched against Mr. Osborne individually, but also in his official capacity. It's couched against Mr. Bracknell only in his official capacity, Mr. Rothwell the same way, and Mr. Walden the same way. Now, as such, because it's in their official capacity, they're entitled to legal representation for that. And had the matter gone further, sadly, we are going back into Ford case number 2.
Right.
Meaning, is the insurance company going to pay for it? Are we going to have to do it ourselves? I see premiums going up for your insurance, etc. So my position was then, you lawyers need to resolve the matter. And if you resolve it because of the potential conflict of the mayor and council, because they are financially interested, that must be approved by a superior court judge, not by the mayor and council. And that's what was done. And before it ever came to y'all tonight, it was given to him for his review and his approval. And that has been done. Now, there's one other thing I need to say, and that is an apology to you, because what I should have done is long before tonight, I should have given to you the documents, anything you wanted, like the complaint and the answer and that sort of
It didn't
thing.
affect us, kind of stay out of it. It's what
Well,
it didn't affect us. It wasn't a city problem, but evidently it was.
It was, and it would have been, as I was trying to say a while ago, poorly, it would have become a terrible city problem if it continued, and would have mushroomed into side disasters for the city when they need to work together. But my failure, too, of many that I have, is that I should have, when I saw it heading in this direction, whether you want to see it or not, I should have given it to you, told you where we were, given you the back and forth between the lawyers, the proposals, and all those sort of things. And I did not do that, and I'm sorry. You deserved better.
Could I ask a question? Am I allowed to ask a
Which
question?
is weird that this is not on the agenda, no public comments on the agenda.
So people don't get.
Okay, so I guess my next
We don't get
thing,
to talk.
my next thing is this, in doing this and doing this and moving along, is there a way that we can be,
Sorry.
I guess, okay, what of this, and I guess, you know, what of this at this point, because my understanding of reading this is this has been dismissed. It's been dismissed with prejudice, so therefore it's not gonna be able to come back up again. So this issue's been dismissed, so that leads me to my last thing, and it's already signed, but the only problem I have with this, and I don't know if you can fix it, is when I was reading it, you know, and I totally agree, you know, the mayor's not gonna receive any of his past legal bills that he claims he's paid till he can produce a receipt, paid or unpaid. Y'all's lawyer fees are supposedly not gonna get paid until there is a receipt that an open record can be made up, and that check is cut from this city to be followed. I have a problem with the fact that when it says Mr. Osborne can get up to $2,000, there is no mention that he has to provide a receipt. And I'm not okay with that.
That's an excellent point, and it's not in there, and they did not catch that. So I think for purposes of the minutes, Madam Clerk, we need to say that Mr. Osborne would need to show the receipt for that so he can be reimbursed. That's a great point.
Because the motion was for $400, so when I saw the $2,000, I was totally, you know, all right, that's what I had.
What this lawsuit cost the city of Temple over $18,000. Is that correct?
That's correct. Mr. Osborne.
The reimbursement, the amount that was actually paid to these ones was
That's not going
$502.
to be way less than that, so we'll be receipts provided.
Any other comment?
I just have a comment in the,
Hold on one second before we end that. Are you saying that the only amount outstanding you're owed, Mr. Osborne, is $502?
Yes, it said up to 2,000, but the amount that was actually paid was $502.
Let's be sure we make that note for the minutes. I'm sorry.
I just have a comment in the court-approved settlement, item number 1 states that the 2010 City of Temple Charter is the governing document for the City of Temple. And going back to the charter, Section 2.16 is very clear and plain. It says the city council is vested with all the powers of the government of the city. Excuse me,
I'm sorry. I'm sorry.
I have the floor.
I realize that.
Rude. Kind of working together.
Yeah.
The handbook that came into question was adopted April 6, 2009. The current city charter was voted on, signed by the government, or by the governor, June the 10th of 2010, 14 months later. So the city charter is the ruling document, not the handbook. So that's it.
Any other comment? Do I hear a motion to adjourn? Oh, go ahead.
I just want you to be clear on number 10 on this, Mr. McCray. I have a question.
Okay.
Right. This is not a new thing that just came about with this agreement. Parties agree and understand the charter provides the mayor with the power to appoint and remove officers, department heads, employees with the approval of city council. That was already stated in our charter.
Yes, sir.
I'm sorry, just one thing real quick. What Mr. Walden said, that is accurate, but the charter, which if you pull up on our webpage, still dates it as 2009. Because the charter was written at the same time the handbook was written. It just took several times to get the council members to have the unanimous consent to get it approved. So before we get up here in a council meeting and act like that handbook was no good, when we have disciplined and terminated numerous employees before I got here with that handbook, I do not want to open anything up to unfair with the handbook, please.
Well, there's the charter laying right there.
Yes.
What's the date of approval?
The date that it was signed. But we had a
It's not
handbook in writing.
2009.
June 2nd, 2010.
Rest my case.
Do I hear a motion to adjourn?
All promotion is in.
Second?
Second.
All in favor? Say aye. Aye. We're adjourned. Shut that off. Chris, turn that off.